Now on to our final session, and this will be covering some of the complexity highlighted in that poll. This will be data protection and policy for the programmatic advertising industry. We welcome Ninon Vagner, Privacy and Compliance Manager for IAB Europe. And then I will lead the next panel of experts in a discussion to explore what the overall sharing of data really means, and will outline the latest policy developments, including ePrivacy, that industry must be aware of. So over to you.
Thank you, David. So for this discussion related to the recent privacy regulatory and technical updates and latest policy development in the EU, I am joined by 4 speakers who have great expertise in privacy and knowledge of the European data protection framework. So we are going to start with a short roundtable to let them introduce themselves and their companies. Beatrice, would you like to start?
Sure. Hi, everyone. I'm Beatrice Botti. I'm the VP of Global Data and the Privacy Officer at DoubleVerify.
Erdem, over to you.
Erdem, and I'm working as a team lead of account management programmatic in AdColony.
Florian.
Hi guys, I'm Florian. I'm one of the managing directors at Zeotap and responsible for a global ID Plus initiative, and also responsible for the global data partner business, as well as publisher and platforms business, and also our legal and privacy practice. That's why I'm here today.
And finally, Lawrence.
Yeah, hi everyone. I'm Lawrence, I'm a solutions engineer here at OneTrust, focusing on our preference choice offering, which essentially is everything about consent on your different digital properties.
Thank you, and thank you to all of you for being here. So just before we start, I just want to remind everyone there will be Q&A at the end of the session. So do not hesitate to enter any question you may have, and we will go through them at the end. So let's start first with a retrospective of what has happened in the past years on the regulatory front. So we are almost 3 years after GDPR came into force. Yet there has been a number of case laws and DPA guidelines this past year that clarified its interpretation, and some of them have been quite impactful for the advertising industry. Lawrence, OneTrust operates a consent management platform that is used by many publishers in the EU. What have been the most important regulatory developments in your opinion, and how did you adapt your product?
Yeah, I'm going to go with the CNIL's most recent changes that sort of took force from the 1st of April. The French market is something that's close to my heart. I also speak French, so I may be biased with this one, but it's something that's impacted us greatly, and we've had to add in a number of different elements to product to help manage that, and also work with our clients to make sure that they could update their CMPs to include things like the continue without accepting button, although not a requirement under that, but it was something that the CNIL had given as a suggestion of how the CMP could be delivered to users. And so it's just been a continued sort of last couple of months of a lot of work of making sure that we were working with everyone, making sure that everything was in place and that everyone understood what they needed to do and how this was going to impact business and what it was going to do to things like opt-in rates and etc. Moving from implicit consent to a very much explicit consent for everyone. Yeah.
Thanks. And Erdem, what ruling caught your attention recently? Because there has been lots of scrutiny on the web environment, especially with regard to cookies. So how does it translate for the mobile app environment?
Actually, the Planet 49 was very impactful for our in-app solution because, yeah, it's always on the industry. They are talking about the cookies in there, but also it's about the permissions, and you have to focus on the opt-in rates of your publishers. And also for last maybe 6 months, we were working on that, and it was very impactful for us because, of course, in the in-app solutions too, our advertisers clients would like to just reach the right people and right target audiences, and we all had that target audience based device IDs and the data's not opt-in, just opt-out. And after the Planet 49 and the similars, of course, we needed to change the structure on the internal side, and right now we are working with several publishers, and actually it was a massive just workload to work with them on the SDK levels, and we needed to change the technical stuffs. And yeah, after the cookie world, actually on the in-app side, it doesn't affect our solution so much, but of course, like Planet 49, they just improve the impact of the permissions. They affected us so much, yeah. But right now we are jumping on that.
Thanks. And same question for you at Zeotap. The Planet 49 ruling also confirmed that the ePrivacy directive applies in Germany, although it's not transposed in national law. Has it impacted your operation as a German-based company?
Yeah, so as you said, certainly a special one for us being a German company, but we're actually active across the European Union as well. Being also a company actually dealing with partners who actually share data with us, right, for different use cases. Consent and actually the way consent is being obtained has been a key measure for us and a key topic. We're consulting our partners, we're working with them closely to actually make them compliant and ensure that the data we are processing from our clients, from our partners, is always following the current rules. If you're looking at Planet 49, what does this mean? It ultimately clarified the aspect of explicit consent. We saw that beforehand, the ePrivacy directive just said valid consent, right? And now with the ruling and the clear interpretation of the Planet 49 judgment or ruling, we actually saw that explicit consent is required and what this actually means. And that also the GDPR in relation to ePrivacy is directly applicable. And actually it took away a lot of uncertainty and it really helped the German market, we believe, to accelerate, right? Adoption, we saw publishers changing actually their consent notices in a rush almost. And for us, this was actually a very positive thing because it gave the market clarity. It allowed partners like ourselves actually to work with them now. That's like this general aspect or concept of consent and explicit consent has been adopted.
Thanks. And Beatrice, how do you approach this scrutiny on AdTech compliance in the EU at company level? And do you think that there are common learnings to draw from all of these recent regulatory developments?
Yeah, for DoubleVerify being a cookieless solution that does not require a large amount of data, if at all, a lot of these rulings have just been the kind of thing that we pay attention to, but have not affected our operations. I think one of the more interesting ones for me personally was the Grindr decision, just because among the interesting things that came out of that decision was a fine that many thought might be unrelated to the company's revenues, which was an interesting aspect. The fact that it was a confirmation of the need for consent for data sharing, which I think most people logically assumed, especially in the context of Grindr and the kind of information that an app like that would have. I felt like it was more of a confirmation, not necessarily a ton of new information for the market. What I thought was really interesting was the investigations that came out of that decision on the companies that were receiving the data, because I think it raises the question again of to what degree is someone receiving data responsible for another controller or another company. I think that the law is relatively clear as to your level of responsibility for your processors. But when you're receiving data from a controller, I think it's interesting that numerous investigations resulted from that decision, just because I think it, in a way, it could raise the bar for all of us. And I think it poses the challenge of any one company works with hundreds of other companies, and it's really hard then to coordinate everyone's interpretation of the law and everyone's preferences. So I thought that was an interesting decision. And as a company that works with a lot of really large tech companies, that's all, and us being on the smaller side, that's always a challenge, right? Coordinating everyone's perception and understanding of the law with our own compliance framework is probably one of the biggest challenges we have.
Thanks. And yeah, you talk about perception and different interpretation of the law. And what another aspect impacting as well the industry are the discrepancies in GDPR interpretation by DPAs, which remains a pain point for most companies in the industry, especially when they operate across markets. In practice, Lawrence, do you observe lots of regional differences in the way user transparency is provided and consent obtained by publisher using your CMP?
Yeah, absolutely. I think it's a very difficult subject. I think it's going to be one of those things that if this continues to happen, if interpretation of GDPR continues to fragment and there's different rules for everyone, it's going to be incredibly difficult for small, medium enterprises, companies that don't have large legal teams to understand exactly what they need to do in each of those. It's to the point where not wanting to pitch or anything, but we have an entire part of our product that helps with that problem because it's a problem. And saying that you need to have specific rules for France where you can only store your consent cookie for 6 months versus other places within Europe where that isn't a requirement, that coincidentally also is in Ireland. So it just, yeah, I guess it's a really difficult one where sort of little things get added and little things get changed here and there for each data protection authority. And I think it's going to be a growing challenge if that carries on, and especially for those smaller businesses where they don't have people to research this and make sure that everything is always up to date all of the time.
Thanks. And Erdem, what are the challenges for a vendor operating across market in the EU?
I'm totally agree on the just lack of employment on the legal acknowledge, because on the especially for the small companies, it's a very huge trouble that they don't have, maybe they acknowledge on the legal issues too much and they don't have teams for that. And also from the supply side, we have a challenge that tell our clients the legal issues about the other regions. For example, we are working for all EMEA and Latin America, and we have some hubs on the industry, by the way. For example, in Middle East, Dubai is a hub, and they would like to run similar campaigns to different regions on the North Africa and also the GCC countries. And if we have some legal differences between the regions, we have to tell them about that one to agencies and the brands too. And it's also very hard for us on the supply level. We also have a challenge about telling the differences and also the reasons of the differences. So we think that we need to just stabilize that one for both supply side and also the demand side too.
Yeah, and Florian, do you think that this is just the adoption curve and there will be more uniform and consistent interpretation of the law in the future?
Actually, yeah, I would like to take a bit more of a positive perspective on this. We have also lived in a while actually before GDPR was effective, and we have seen how different actually regulations in Europe could be. And we employed actually large forces of lawyers in each of the markets to ultimately understand and interpret the local laws. With GDPR, first of all, right, we actually introduced not a global, but a European framework, which really helped to simplify things. Of course, right now, actually, individual regulators in the markets are like starting to interpret more closely and actually more in a detailed way, which is, I would say, a normal learning curve, right? We are getting to new standards, and ultimately, these are reactions to local developments. And what is a positive, I think, is that actually the regulators from the different markets look at each other and actually copy and adopt new standards there. And that is a process. Of course, it's painful in between. And of course, it means complexity. If you look at it from a different angle, it also means an entry barrier. For companies like us, being a European first company, it actually helps us to better understand the markets than other potentially multinational companies coming also from the US and other markets, and is ultimately delivering a competitive advantage to us.
Yeah, and the EDPB is a big part of making sure that the interpretation is consistent. Although no, it's not, well, the UK is not part of the EDPB anymore, and it has transposed the GDPR in national law, and the adequacy decision is currently on the table, but there might still be differences in the legal regimes in the future. Beatrice, are you concerned about the UK framework being ultimately different than in the EEA?
I'm always a big believer, like Florian, on the bright side. I think that there's considerable market forces that will encourage the UK to stick to a more beaten path when it comes to their own choices. It's a little bit, I remember back in the day, during all of the Brexit debates, where everybody was like, oh my God, there's going to be a different standard for cars. So you'll be able to sell a car in the UK, but not in Europe, or vice versa. And I remember one example about the regulations for pillows that the Brexit campaign was really clinging to, saying, see, Europe wants to regulate pillows, which is very important for your neck and posture. But I think we see that in the United States with California. California is always the outlier with decisions, and everyone was like, oh my God, we're going to have to cater to California. And that never comes to pass. We don't actually cater our lives to California. So I feel like at the end of the day, the UK will be encouraged on a general strategy to stick close to the market that they engage with the most, which I think is going to be the European market long term. I think that's definitely one force in that direction. The other thing that I think can't be ignored is that the other big market for the UK is the United States, and the United States is moving in the direction of stronger privacy laws. So everybody is rowing in the same direction a little bit disparately. I think what's really interesting, it's funny that I agree with Florian that there's a lot of bright side to it. I also tend to be positive about things, and the way I see it, having been on most of my life on the side of the smaller vendors, I actually like it when DPAs come out with decisions, even if there's 27 different decisions in Europe for every country in the European Union. It's fewer than the clients that I have. So if I have decisions from a DPA that interprets something and a client is trying to push me in a different direction, I can always say, look, this is the guidance that the DPA has provided. This is what we're going to stick to. Insofar as your compliance is concerned, I'm completely respectful of yours, but for us, this is what we're going to do. And now I have someone legitimizing that approach that is the person, the entity that makes that decision. So I feel like you can look at the bright side with it. And then as a small vendor, I think most of us live in the world of strictest common denominators, right? Like I have lived my entire life saying, okay, who's got the strictest requirement? Let's just go with that. And if we can make exceptions for more flexible ones and it's operationally feasible, that's what we will do. But if we can't, this is the most scalable, most efficient way for us to comply with all the requirements. And that's what it is. It's definitely not an ideal world, but to Florian's point, it's like more ideal than it was before. And it's not anything different. 209 sovereign nations and 200,000 different privacy laws. Not terrified.
Thanks. Let's now move to the current technical challenges that are driven by privacy objectives. So they disrupt how the industry operates, this time in a consistent way. So first with Apple's app tracking transparency feature that has been released on iOS. What has been the impact, Erdem, of this new prompt for publishers? And what are the alternatives when the IDFA is no longer available?
Actually, we were working for that maybe just for the last 1 year, and we have several publisher partners for each market, and also they have just worked a lot about that. And yeah, we have some solutions about that, but first of the story, we needed to find and to understand all the technical solutions that Apple also just gave us, the SCAD network. And also we were working on it on the SCAD network, and according to the ATD and the banning of IDFA. Right now we are working with our publishers to increase our opt-in data, and also we are tracking how the trend is going right now, and they started to just get the permissions to the users directly. But also the first party data is very important in here, and as the network, actually we have an advantage for that because we have our direct SDK, and just after the IDFA, some of the ad networks that they have mostly reseller of the inventory could be affected because they couldn't get the data, and even if they have, the publisher has the opt-in data, they couldn't reach that. That could be a trouble, and also it could be pushed to some companies that create their own SDK, or if they have, they will try to penetrate the publishing inventory to increase their SDK penetration. And right now on the mobile in-app world as a supply side platform, we are working to increase and also to follow how to opt-in data is going on. And yes, it depends on, by the way, the effect depends on the region too, because that we have also the Android inventory too. In some regions also, Android has a very huge penetration, and yes, in that regions we don't have any changes on the ground, but yeah, especially in Europe and also the US, we had some effects, and with that regions especially, we are still working with the publishers to increase the permissions and opt-in data. And also we are trying to make it wider and make it a little bit more special, because before that one, we had the interest data and we have some classifications, and right now we are starting the story again. And with the contextual also, we are supporting that with the publisher team. So it just pushed us to work with publishers more than before about the targeting and about the data classification. And yes, from the supply side, updates are like that.
Thanks. And Lawrence, how this new feature is handled by app publishers? So how can this prompts articulate with their own consent mechanism, which remain in fact necessary to gather user choices over their personal data, irrespective that the IDFA is no longer available?
Yeah, so I think there's two parts. There's the part where we still have to have all of our CMP appearing under, as we had the requirement for before. We've also got that requirement where if we're going to do any targeted advertising or try and reuse that person's data across different apps, we're going to also have to request IDFA. And I think really the biggest impact it's going to have is on that user experience. of users now seeing too many pop-ups. I saw like a little anecdote the other day where someone clicked on a link because it was an article they were interested in, and they got to the article and they had to accept alerts and notifications, and then they had to sign up to an email newsletter, and then they had to accept cookies. And it can end up being quite bad in terms of user experience if we have all of these pop-ups. What we're trying to look at doing and trying to make end up being better, some of the options that are there are, number one, testing banners. A/B testing would be the first place to go to just see what kind of banners you can end up having that will have the least impact on a user's actual experience, detrimental in any case. But also maybe look at things like having certain pages where you've got a very clear call to action, not have a consent banner. Obviously, we can't collect various information based on consent from that point. It would have to wait for a further point in the user journey. But maybe if there's a very clear landing page with a call to action that we've already got, we only want one of those. We don't want to then throw up a banner there in place as well. The other bit will be, I think, in terms of how to improve this, is going to be looking at things like authenticated consent, storing consent in the back end for a known user, and making sure that if a user goes through different steps, that we can collect and use that consent they've already given, rather than presenting them the same banners multiple different times, so that when I go onto the website, I can accept cookies and accept tracking in that sense. And then when I go onto the app, well, I'm not seeing that now because I'm on iPhone. I'm not seeing that, but I am going to see the IDFA prompt still. But so we're contextually building that as we go, rather than just bombarding all of those in one go. I think is going to be really where things will have to improve to make sure that we still have good user experience and make sure we don't have that sort of bombardment of different elements on the page.
And so, Beatrice, there is a clear misalignment between the role of the end user agent and the role of the publishers when it comes to obtain users' consent. And ultimately, this leads to the very fragmented and confusing user experience that Lawrence just described. How do you see this evolve, and should have the ownership over user-facing components?
Yeah, I think that every time there's an evolution in either the collection technology or the law, which usually do not happen at the same time, one comes way before the other. I'm going to let you guys guess which. But when that happens, there's always an adjustment period. And then at some point down the line, a consensus forms over how things are to happen. Or one of the bigger players makes an executive decision about how we're all going to be moving forward, moving forward, like Apple did with IDFA, or Google decided to do with Chrome and cookies. I think in the world of CTV, for example, in the past panel, everybody was talking about how it's the next big opportunity and how we expect that to grow. I think we're still in its infancy, so there's still a lot of debate, right? I think CTVs are more static than a lot of other devices that we've experienced in the past few years. As it always happens in the industry, there's always like an up and down. Like we went from desktops to laptops to smartphones, so moving towards the mobile concept. And now we're like going back to more static concepts around the Internet of Things. Most of the Internet of Things are in your house, so they're not going around anywhere. I think that lends itself to position the manufacturers of the devices to be closer to the user and to be better positioned to predict where the user might be, because my smartphone travels with me. So I could be in Italy. I'm originally from Italy, so I could be in Italy visiting my family next week. Maybe not next week, but at some point, and I could be in the US today. So that creates a lot of challenges in figuring out what level of consent am I required to gather, since it's unpredictable where my smartphone might be. I think with a CTV, it's a little bit more predictable. Not a lot of people bring their 60-inch TV across the world. I'm sure some people do. But I think that definitely will be a factor in the decision. But at the end of the day, I think it's a situation in flux, and Lawrence and his team will figure out how to get consent when everybody figures it out, and the rest of us will like travel in that direction once the big decision is made. I think for a lot of vendors, you're sitting on the sideline waiting to see what happens and trying to stay ahead of the curve if you can, or just be on the same train if that's more feasible.
And another topic, of course, talking about end user agent, the deprecation of third-party cookies by Chrome and the alternatives that are currently being discussed. Florian, can you give us an overview maybe of the different solutions, and what are, in your opinion, the alternatives that will gain the largest adoption between identity solution, publisher-provided IDs, or the privacy sandbox APIs?
Yeah, thanks for directing this question to me. It's actually something we've been working on for the last 18 months, right? With Zeotap and our ID Plus solution. We started out actually building an authenticated solution, which is ultimately using logged in users to connect them in the future without cookies. But of course, the industry and the world will be much more complex. We cannot only look at one small piece of the puzzle, which would be authenticated solutions, but there's much more. And if you, maybe to make it easier, to put it in a pyramid, there are actually different layers of this pyramid. And at the top, there's just very small scale, but high quality. And this is ultimately, that's the authenticated game as we see it today. Because users are not logging in at scale yet. Publishers who achieve 20 to 40% logins are really well off. Of course, the industry is headed towards this and is really using 2021 to develop strategies, to develop actually maybe just login walls, maybe soft logins, ultimately nudging users to authenticate themselves or identify themselves in different ways. Still, right, this is going to be a smaller piece of the pyramid. As a second layer, you have the cohort-based solutions, or you could say privacy sandbox concepts, right? Where ultimately Google is pushing the industry, or the industry should be collaborating on this to ultimately develop solutions as an alternative to cookies, which should be more privacy compliant. As we all know, that's not yet being tested in Europe, so we don't know yet when we'll ultimately get there. But still, this is certainly something which will be part of the future. And as said, it's not only cookies anymore, it's already two technologies, right? And then, of course, there's the third aspect of contextual. And contextual targeting has always been around. It's certainly being more and more professionalized, I would say, or automated in certain ways. And this is also something there to stay. But now you're going down the funnel, or not even funnel, a pyramid. And at the bottom right, you have big scale, because contextual you can get almost anywhere. But you're going down from a quality perspective. And some solutions, and if you're just looking to actually target a certain behavior or context of people, that might be enough. But if you're invested as a brand in actually highly complex data analytics projects to figure out which are your user groups who are prone to churn next, then you want to reach exactly that group. And that's actually where solutions such as authenticated ID Plus solutions are coming in and ultimately are the only option in the future to connect you to, or deterministically connect you to audiences on the publisher side, in the same way walled gardens are able to do that. And ultimately, if you look at these three elements, of course, they are the walled gardens. And to a certain degree, they're being strengthened. And that's in our other side of the business, right? Where our customer intelligence platform connects you to all these different aspects of the advertising ecosystem and allows an advertiser to ultimately choose and mix these different channels to join the user through in the entire journey.
And Laurence, what role can take CMPs in this new landscape? Can they be combined with sign-on component, for example, to support the identity solution that Florian mentioned?
Yeah, I think that can tie very well into that idea of authenticated consent. If we've got an identifier for someone and we know who they are, we know their device or their user ID typically would be, from our point of view, as a CMP, agnostic over what the ID is. But those kind of solutions are perfect because we can say, oh, we know this person is the same user, they've given us the consent. We can pass that over through the different domains or different digital properties in general that they're moving through.
Let's move now to the recent policy development because we have only 5 minutes to go. So first with the ePrivacy regulation. So last February, the Council agreed on its version of the text and the final negotiation should start at the end of May. Beatrice, is this finally moving in the right decision? Is replacing the ePrivacy directive with a more up-to-date regulation is essential for the industry?
Yeah, I think you'd be hard-pressed to find someone who would say, "What? Let's keep the ePrivacy directive. I like that one better." The law is from like the 90s. So the internet was a very different place. I think it's pretty common for technology to evolve at a different pace than the law, but in this specific instance, I think we've probably waited a little bit too long with replacing this law. I think GDPR in a way complicated things because it created similar but separate standards for the processing of the same data. So it creates a lot of complication. It's actually an aspect that I spend a lot of my time working on, because DoubleVerify's processing is legitimate interest based. We're cookie free, but we do some level of pseudonymous information tracking. It's very distant from identifying who the person is, but under the law, it is personal information. But it is based on legitimate interest, and the ePrivacy directive really complicates our lives because it creates separate and differing standards that just in a way overcomplicate the situation. And the draft of the ePrivacy regulation that we have now actually addresses a lot of these concerns head on. Fraud elimination is addressed head on. Whether or not paywalls for data tracking are legal is addressed head on. So I think it is an improvement. When the GDPR got to this stage, it still took 18 months and then 2 years for it to become enforceable. So I don't have high hopes that 4 years from now, the internet will be the place that it is today. I'm still holding out hope for flying cars. I do think at this point, any improvement is good, because right now we're getting tied down with regulations that are regulations is a technical term, but with mandates and laws that are technical interpretation of a law that wasn't designed to deal with the world of today. And I think that complicates the situation a lot. I do think my hope is that the ePrivacy regulation will somewhat, maybe unexpectedly, simplify things for at least some players. I know it would for me, so I would definitely welcome it.
And so one last question for Florian before we wrap up. Do you also share Beatrice's view, which is quite positive about the latest text? Is it sufficiently strong to support the ad-funded business of certain publishers? Also in light of the Parliament's position, with some MEPs suggesting a ban on targeted advertising?
Yeah, I think at least, first of all, I actually second the assessment that this is going to be a while until we'll see it in effect. And at the moment, I think some of the early timelines are looking applicability not before 2025. So there is actually still some time to go. And already, if you're looking at the draft right now, it's all about cookies. And the interesting thing is, you just discussed or mentioned it, the depreciation of cookies is happening next year. So we are already looking at a draft which at least doesn't differentiate between third-party and first-party cookies, or what is actually meant there. So we are seeing that regulation is lagging behind, right, the reality in technology. That is just a fact. It's always been, right? But we need to make sure that this regulation now at least hits a few of the important elements. And I would actually agree that many of the, let's say, common topics at the moment in the industry are at least addressed. And yeah, if they're going to be solved, right, in the, let's say, political discourse of trying to find compromise, will be interesting to see. I think it's too early to say. At the moment, at least elements such as, and I'm just picking one, having a very clear accept or decline ruling on how actually I agree as a user, and potentially then also having more clarity on how actually consent mechanisms need to be designed as a general rule, or also having the general browser-based whitelisting of certain cookie types to make it easier for users, not always have to click on a cookie banner, but not ultimately fight this fatigue, right, of cookie banners, and then rather decide on certain actions which are actually relevant for the user. These are good things, and they can actually be quite valuable for the industry if they're being done. And that is something, I think, for all of us to wait on.
Yeah, so definitely something to monitor. I think that we can now close this panel because we are slightly over time, and I see no question from the audience. So thank you again, Beatrice, Erdem, Florian, and Lawrence, for your insight and expertise on the topic. I will now hand over to David to close today's event.
Thank you very much, Ninon, and all the panelists. It was a fantastic panel, and I'm sure many of our audience had lots of takeaways there. It sounds like we have a really interesting and uncertain future ahead of us with regards to privacy, but it is clearly the reason why we need to stay plugged into this topic as much as possible.